Hello! In this video we're going to look at trademark registration. One of the first questions people ask about trademarks, and one of the most interesting ones, is what can be a trademark? Well, trademark lawyers use the term sign to refer to the word or logo or image before it becomes a trademark. So a sign has the capacity to be a trademark, but once it's actually registered, it's then a trademark. So sometimes when we see the word sign, we can use that interchangeably with trademark. So a sign is typically a word or words or a logo or an image. But in actual fact, a trademark can be anything at all, subject to certain criteria. Now, the main job a trademark has to do is to distinguish the goods or services of one undertaking from those of another. And provided the sign can do that job, it has the capacity to be a trademark and to be registered. Trademark registration offers a number of advantages. When you have a trademark register, ownership is very clear. You know, the trademark is there, the owner's name is there, and it's very clear who owns it. The priority can also be clear. So if you're in a first come, first serve situation, well then the first person to file the application for the trademark is the person that gets it. And so that can help resolve issues that would be difficult to resolve without registration. If there was no register and two people were claiming that they were the first, it would be hard to see who came first. A trademark register is also very useful for competitors, because any potential competitors that want to use a trademark can check in advance to see if someone else is already using it. And if it's already used, well then they'll go away and pick something else. Now, Article 4 of the EU trademark regulation specifies what can be a trademark. And it says that a trademark can be pretty much anything. And it even gives some examples. It says colours or shape of the goods or packaging of the goods. It even has sounds in the list. But there are two criteria that must be met. The sign must be capable of distinguishing the goods or services from one undertaking from those of another. And that's the main job of a trademark, and the sign must be capable of doing that. There's a second then technical criteria, and the trademark must be capable of being represented on the register. And that's a technical constraint. So the EU trademark regulation is quite flexible about what can be a trademark. In principle, no kind of sign is ruled out. Anything can be a trademark provided it can do the job of distinguishing the goods and services, and it's capable of being represented on the register. So there are all sorts of possible kinds of trademarks then, in addition to words and logos and graphics. One of the more interesting questions was whether a smell can be a trademark. Now, one of the most unusual questions that has come up in EU trademark law is the question of whether a smell can be registered as a trademark. And it's possible to imagine how a smell could distinguish the goods of one undertaking from those of another. So it's possible to imagine, for example, that tennis balls that smelt like strawberries could be associated with a particular manufacturer of tennis balls. So it would certainly have the capacity to distinguish the goods. But how can you represent a smell on the trademark register? And that's a question that came up. Now, the question of whether a smell can be represented properly on the register was considered by the Court of Justice in Sieckmann. So Sieckmann wanted to register a smell as a trademark in Germany for various services. But the German Trademark Office refused, and so he appealed to the Court of Justice. The Court of Justice upheld the German Trademark Office's refusal, and in doing so set out the criteria for the representation of a sign on the register. The court noted that the precise subject of the protection afforded by registration needs to be known. So trademark offices must know what the sign is with sufficient clarity in order to carry out its duties. Also, competitors must be able to consult the register and find out with clarity and precision what belongs to someone else so that they don't infringe. So the representation on the register must provide legal certainty. Now, Sieckmann provided the chemical equation for the smell, for example, okay? And he also provided a mechanism by which someone could get a sample of the smell. So he said samples can be obtained from various laboratories, and he said you can find that in the phone book, for example. He further submitted a sample container with his application, so it was a little, test tube with a sample inside. However, the Court of Justice found that this was not sufficient. It found that the smell cannot be represented graphically by a formula, a description in words, nor by a sample, nor by a combination of them. And in its ruling, the court set out what have become known as the Sieckmann criteria. So in order for a trademark to be represented on the register, it must be clear, precise, self-contained, easily accessible, intelligible, durable, and objective. And in Sieckmann's application, a number of these criteria were not met. So a chemical formula depicting the scent did not represent the odor of the substance. It was not sufficiently intelligible nor sufficiently clear and precise. The written description was not sufficiently clear, precise, and objective, and the physical deposit of a sample did not constitute a representation because it was not sufficiently stable nor durable. So in Sieckmann we learned that a smell can in principle be registered as a trademark if it's capable of distinguishing the goods of one undertaking from those of another. But it's difficult to see how the requirements for representation could be met. It's difficult to see how a smell could be represented in a way that's clear, precise, self-contained, easily accessible, intelligible, durable, and objective. If I was to say my product has the smell of grass, what does that mean? Is that objective? Is that precise? It's difficult to see how a smell could be represented in a way that meets all of the Sieckmann criteria. What about a colour? Can a colour be registered as a trademark? Well, the issue of single colour trademarks came up in Libertel. So Libertel applied to the Benelux Trademarks Office to register the colour orange. Now, the Trademark Office refused, and the Hague Supreme Court referred a number of questions to the Court of Justice for clarification. Now, on the issue of representation, the court ruled that merely reproducing on paper the colour in question was not sufficient. I think in this case the applicant had actually stuck a colour chip onto the form. The court ruled that an internationally recognised colour identification system code could satisfy the requirements. And there are plenty of recognised colour systems. Pantone is a famous one that designers use, but there's also the RGB system, the CMYK system, and a few others. The question of whether a single colour had the capacity to distinguish the goods of one undertaking from those of another, though, was more complex. So this was the question, can a single colour, without any text or logo, just the colour alone, identify the origin of the goods or services? And the court found that, in general, a single colour by itself would not have the requisite distinctive character. However, if the colour was used long enough in the trade, people might eventually associate that colour with the provider of the product or the service. And this is provided for in the trademark regulation. It's known as distinctive character acquired through use. And the trademark regulation says, if the trademark has become distinctive in relation to the goods or services for which registration is requested in consequence of the use which has been made of it, it may be possible to register it. So a single colour, all on its own, could be registered as a trademark, provided the applicant could produce evidence that it has become distinctive through use. So let's have a think about what that means. So suppose you're on the street and you see a guy delivering a package and he's all dressed in red. Would you think, okay, I know what delivery company he works for? Probably not. If you saw a guy all in blue or all in green delivering a package, would you say immediately, aha, oh, that's whoever? Well, probably not. But what about if you saw someone in brown delivering a package? Well, then you might go, aha, that's actually UPS. So UPS has been using brown on its uniforms and on its trucks for so long that we have come to associate that colour brown with that service provider. How about a sound? Can a sound be registered as a trademark? Well, I think it's quite clear that a sound has the capacity to distinguish the goods of one undertaking from those of another. But how can a sound be specified on the register? And can it be specified sufficiently well in order to be registered as a trademark? Well, the court has found that musical notation is sufficient to represent a sound. So unlike a chemical formula which was found to be too inaccessible, musical notation is sufficient to represent a sound. Now, when the register was on paper, the sound had to be represented graphically, and this posed quite a difficulty. But now the register is digital and online, and it's possible to simply upload an MP3 file of the sound. And this meets all of the Sieckmann criteria, and anybody who wants to see precisely what is registered can do so. And here's an interesting example of a trademark that's been filed electronically. So that's a registered trademark. Here's another sound mark. And that's registered by MGM. What we're looking at here on the screen is a graphical representation of the sound. And this is something that was used prior to the possibility of uploading an MP3 file. It's difficult to see how this would have met the Sieckmann criteria, but this is the kind of thing that was used back in the day when the representation on the register had to be graphical. It's hard to imagine, though, that many people looking at this would be able to understand what the sound was. A shape can also be registered as a trademark. But unlike sounds or smells, the representation of a shape isn't a problem. The difficulty a shape might encounter is that it might not be recognized by consumers as a trademark. And so if it's not recognized, it can't do the job of distinguishing the goods and services. So a simple shape might not be recognized as actually being a trademark. And so this shape was found to be incapable of functioning as a trademark. This shape suffered a similar fate. It was found that this would just be perceived as a simple parallelogram and not understood by consumers to be a trademark. The little piece at the end was considered too subtle, and so this was found to be incapable of functioning as a trademark. Once you know what it is, you go, aha, I see now, I recognize that. But without the Air France, on its own, it was considered too plain and so couldn't distinguish the goods. This shape was also found to be incapable of functioning as a trademark. If you're into sports, you might recognize it as identifying Barca. A 3D shape can also function as a trademark, but where the shape is the shape of the goods themselves, things become more complex. Consumers don't typically understand the shape of a product to be a trademark. The most famous case was Kit Kat, and here Kit Kat argued that when a consumer sees this shape, they understand it to be a Kit Kat and nothing else. Mondelez wasn't successful in this case. The shape was found to not possess the distinctive character. Mondelez argued that it had acquired distinctive character through use, but it wasn't able to show that throughout the whole of the EU. Product shapes are important, however, and they're especially important in the perfume industry. That's probably because it's not possible to register the smell as a trademark. And so perfume manufacturers have to rely on the shape of the bottles to distinguish their goods. So these are probably recognizable. Others are also quite distinctive, although I wonder, would you recognize all of them without the names? But it's largely because smells can't be trademarked that perfume manufacturers go to such lengths to have distinctive packaging. To recap then, in principle, anything can be a trademark, but it must meet two criteria. Firstly, it must be capable of distinguishing the goods or services of one undertaking from those of another. If it doesn't have that distinctive character in the beginning, it may be possible to acquire that distinctive character through use, but that's something that can only be done if it's been on the market for some time. Secondly, the sign must be capable of being represented on the register. That representation on the register must meet the Sieckmann criteria. We know that images and words, even 3D shapes, can be represented on the register. We know that sounds can even be represented by uploading an MP3 file. But current technology does not allow for smells to be represented on the register in a way that they can meet the Sieckmann criteria.